Os dejo, por tanto, con Javier Díaz Noci. Eskerrik asko, Javi.
Eskerrik asko, eguerdion, buenas tardes. I'm the last of intervening here, and I've been asked to do it in English. That's bad news for all of us, but I may request that. Well, my English is not really English, it's quite globish, so I hope you all understand don't try with that. It doesn't work. So I will try. Well, I'd like to begin my intervention here with a great thank you very much to Professor Koldo Meso and Ainara Rondo and all the organizers of this 5th edition of the Congress on Online Journalism, and probably the most international one, and that's one of the reasons why I'm trying to speak some English, with an increasing international audience. So my congratulations for that, as Dr. Bea Palomo has said as well. And I'm very glad and happy about returning home. This was my home. In fact, I was teaching at the University of Basque Country during more than 15 years, and I was born just 70 kilometers from here in Vitoria, so I'm glad to be able to return home for some hours at least. I'm happy, but at the same time I'm a little bit frustrated because well, I've been told that there was some fun here around during the last 2 days, and I was not told that, so I forgot my Strat at home in Barcelona. I haven't brought it with me. I promise I will bring it with me the next time I'll invite it here, and have an occasion to have a jam session with Professor Magdeus, who is not around. Well, bad news for you. I'm better with the guitar than I'm with legal research, and more bad news, I'm better with Spanish or Basque than I'm with English. But anyway, let's try all together. And let's start proposing an alternative title to my speech, which is this one: a legal approach to intellectual property and authors' rights on user-generated contents. Although, as I will refer later, I don't put the stress on the contents, which is the main thing that acts or laws do, but on the news reporting activity as a social activity. I mean, I put the stress on people, being people, the journalists, I mean the practitioners, or the the people formerly known as the audience, as Jay Rosen said. Okay, this is a schema about the way that intellectual property and copyright works all over the Western world, in both civil law system and in common law tradition. It would be a little bit long to explain it all. That's in Spanish. I suppose, and I propose that my presentation will be hanged on the virtual campus of somewhere on the webpage of the Congress, so you will have it at your disposal. And anyway, I can explain and answer all your questions, being them formulated in English, Spanish, Basque, Italian, Portuguese, or Catalan. The question is that one can compare legal systems, meaning the national law. I mean, one can do some, and it's quite usual to do some research on a national basis, on a ground. I mean, compare Spain with France, or Spain with Italy, or compare the southern Europe countries, or compare, I don't know, France with the United Kingdom. But usually in legal research, in modern comparative legal research, we don't carry on such research. Instead, we prefer to compare legal traditions, which is a different approach and probably a more fruitful one and a more complex one, because we are comparing not concrete laws, concrete acts from Spain and France, for instance, but to compare legal traditions. I mean, civil law civil law that of Roman origin, and is the law of Spain, Portugal, Brazil, Latin America, Germany, Italy, Switzerland, etc., and the common law tradition, which is that one of the countries of English-speaking origin, starting with England and not the United Kingdom, because Scotland is a different case. And after that, of course, the United States, New Zealand, Australia, and so on and so on. Here in Europe, and regarding to this concrete aspect of legal research, which is copyright and copyright of news reporting, we have a quite hybrid case, which is the Netherlands. The Netherlands are a civil law country which has a quite common law copyright act. In this respect, they are quite a mixed tradition. And to some extent, we try to compare as well the remaining of the socialist law countries. In fact, Cuba, which is quite easy because of the language, and China, which is not so easy because of the language, because of some other reasons. But we intend to compare civil law and common law. I mean, a group of countries and another group of countries, I mean, a couple of traditions. And just a note about methods, we try to do that from a functionalist point of view. It means that different societies, and quite similar societies, in fact, Western society, answer to same problems in quite similar ways, even though if they use different legal figures. And we have some occasion to explain a little bit more on that. And from the point of view of law and society, legal research is part of the social science research, in fact, like sociology or communication or psychology or whatever. And as a social manifestation, legal can be considered from several points of view, and not only referring to the literal meaning of the acts. Considering that in the common law countries, when we say the law, we are not thinking about a written code, about an act, but about, moreover, a judge-made law. And that's why we have to refer continuously when we deal with common law countries, more than to acts, we have to deal about judge decisions or reports, or using a Latinate sentence, the doctrine of stare decisis, the precedent, in fact. And moreover, we are interested in focusing on a concrete methodology which is called law in action, not only which are the things or the rules that law provides about a concrete topic like copyright and news reporting and user-generated contents, but how the social actors, for example, companies or practitioners, meaning journalists, or the users as authors, apply those rules and use those rules to fulfill their satisfaction. And as a starting point, we can say that in the last 2-3 decades, coincidentally with the rising of the World Wide Web, and probably that's not casual, we are in front of a harmonization of legal systems, I mean national laws, and the typical case is the harmonization of national laws of Europe, of the European Union, because of the system of the directives that need to be implemented necessarily by those individual members, countries, but moreover to the harmonization of legal traditions. I mean that the so different common law tradition and the so different civil law tradition are becoming to some points of contact, at least regarding and clearly to this concrete topic we are dealing with today. This means, for example, the recognition of moral rights in common law countries. In common law countries until the 90s, in the countries which invented the copyright system, the first copyright act is that of England, the Great Britain, in 1710, the Statute of Anne. And they never recognized the moral rights in such an extent as they were recognized and accepted and was the base of the legal protection of authors in civil law countries. In fact, in common law countries, the approach is quite entrepreneurial. I mean, the motor of the cultural and intellectual activity is considered to be the company. For example, the producer of a TV series, or the producer of the company who produced a film, or even the actor or the actors that appear in that film. On the other hand, in the civil law countries, the stress is always put on the individual person, I mean the creator of a picture, a novel, a news item, or whatever. So in civil law countries, moral rights, paternity rights, integrity rights, and so on, were considered and are considered personal rights, irrenunciable, non-feasible, intransferable. Whilst in the common law countries, instead, they never recognized such rights. It was due to the pressure of the international and transnational organizations such as the World International Property Organization, the WIPO, that finally the common law countries, remember, one of them is the United States, the so powerful United States, recognized in their acts, in the Copyright Act, the moral rights with, of course, some exceptions. Secondly, the attribution of economic and even moral rights to juridical person or legal person, I mean to companies. In the common law countries, it's accepted that moral rights can be ceded or transferred or subrogated to the companies. I mean that a journalist working for the New York Times is not the author of his or her news item, but the New York Times company is. That's unthinkable in our countries. I'm the author of my news story, and I have ceded just the economical rights to my company. But in the civil law countries, we are in front of several legal reforms, starting with the so-called Loi Hadopi in France, that consider that to some extent the economical rights, I mean the originary economical rights of the authors as individual persons, are automatically given to the companies. And that's clearly an influence of the common law tradition on civil law tradition. Instead, the civil law tradition had an influence on the acceptation of moral rights with some limits in common law countries. Thirdly, we are in front of an increasing importance of the so-called collective work. For example, a newspaper is a collective work. I mean, I'm the author of that pictures appearing in the newspaper, but the author of the newspaper as a whole itself is considered to be the company, I mean the juridical person or the legal person in legal terms. And a web page is no more than that. So we are in front of an increasing importance of these kind of works. So all the legal reforms operated in all over the Western world and in this concrete direction, giving importance and attribution of originary rights to the collective works authors, I mean the companies. As a balance of this clear trend, we are in front in some countries, clearly in Germany, Belgium, and Brazil, of the potentiation of the ancillary rights or secondary rights, or referring that in French, droit voisin, or in Spanish, derechos de intérpretes y ejecutantes. And this is the case of the secondary exploitation of the of the works. I mean, you are contracted, you work for hire with a company, say the New York Times, El País or Le Monde, and what happens if Le Monde or El País or the New York Times, which is a real case, sign an agreement saying that, okay, some contents published in El País can be published and translated into French and published in Le Monde and translated into English and published in the New York Times. That's secondary exploitation of the work. And it needed, before the legal reforms, the explicit permission of the author as an individual person. It's no more the case, except when the authors, usually grouped in powerful syndicates or trade unions or associations, are able to negotiate in equal conditions with companies, which, for example, in Spain, is not usually the case. I know it's dense. And it has to do with Google and with aggregators. What happens when Google, to some extent, helps to the exploitation, in one sense, of the contents belonging to juridical persons as authors of the collective works and individual people as individual authors of the individual work. And it adds some complexity to this question. Third trend, and very clear, the trend to extend the exclusive exploitation rights even of third parties' works. I mean, a company receives not only the works of their employees, the journalists, but of the users, which are considered third parties, terceras personas. So what happens when these third parties' works are able to create some economic benefit and the company wants to negotiate with third parties to sell it to the New York Times again and has not the rights? So the trend is to consider those rights from third parties, set it in exclusiveness, which is very important. And fourthly, a trend to attribution of negotiation rights with third parties. I mean, the company is the only one able to negotiate the reselling or the reusing of those works, doesn't matter whenever they come from, with third parties. And in a globalized world, that's extremely important. And that's what they think in The Guardian or in The Independent, Le Monde, Le País, El Mundo, New York Times, Ciberjournalism, and so on, and so on, and so on. Because every one of these companies is a group in themselves with different companies composing those groups. And what happens if a journalist of a user sends a work to the New York Times that want to be published in the Boston Globe, which is a different company belonging to the same group? Which happens is that the groups have created a specific enterprise of companies or firms to manage the rights of the works of whoever who publish whenever and wherever of their media. I know that's complex. That's so complex that when I refer to that, I always think about this very famous thing of those people coming from the Paleolithic. Okay, they were called the Marx brothers, nothing to do with Karl Marx, or maybe yes. About a famous thing about a contract, the third party of the third party of the third party. And this is it. The companies consciously complicated the copyright notice of the terms of use, which are to be considered or not a contract. And that's a question I wanted to deal with. Because if these are the trends, let's forget the moral rights. Let's forget the moral rights. It's based, at least in the civil law countries, in the freedom of negotiation of the parties. As a journalist or as a user, I'm at the same level as the company to negotiate to which extent I can cede my rights on my work to that company. But that's not true. We are not at the same level because they are much more powerful than we are. So the question raised on original rights. If you, as an individual, retain your original rights, you are able to negotiate your own or with a trade union or an association. And wherever the association or trade unions are strong, like in the United States or the Netherlands, it doesn't matter if the act, the Copyright Act, is considered to be weak from our point of view, because they don't recognize fully the moral rights, for example, because they are strong to negotiate. But here in Spain and in the south of Europe, we are extremely weak to negotiate anything with them. And they are becoming more and more and more and more and more powerful because they are becoming more and more and more transnational. Think about how can you negotiate about the content that can be published in the website of the Coca-Cola company. And it has to do, and let's abandon for a little while the law, with a change of the consideration of narrative, any kind of narrative, a news story is a narrative. The change operated on narrative because of the apparition of multimedia, interaction, hypertext, and the consideration of the user or the audience as an author. And terms like transmedia or participative narrative or collaborative narrative are important, as we have seen before. Okay? Theoretically, at least, the audience wants to be part of all this process and participate in narrating things, telling things. So they are, of course, to be considered authors. And this is another extremely important question because it has, and we come again to law, legal implications, which is derivative narrative. Of course, collaborative narrative is a very beautiful term, but in fact, and from a legal point of view, we are much more in front of derivative narrative than in front of collaborative narrative. I mean, when the users send comments to a news story, they're not collaborating in doing the story, they are adding things to that. When they send a photograph, usually it's not published alone, but contextualized with some other photographs produced by the staff of the media company or by another user. So it's more contextual. And more than that, and with fiction is even more clear, the user wants to continue narrative, to continue the story, to continue to rewrite the end of laws, to invent continuation for The Lord of the Rings, to rewrite the story of Tintin, and so on and so on. And it happens, and that's a problem or a chance for further development. But it creates problems with law, because we deal with different types of copyrightable work. The original one, I mean a photograph, an individual one, or a derivative one. A translation of a news story is a derivative work and has different rights on it. It can be single or collaborative. For example, a report or a news story usually is composed by text and photographs and increasingly more and more multimedia presentation, slides, video, sound, infographics, etc., etc. So the importance of the collaborative work is much more than the one of the single work. Forget that. It's quite difficult to find single works in this environment. And collective works. I mean, a web page or a newspaper is a collective work with a different author, okay? And the importance of derivative work, for example, mashup stories, which are much more important in this world. And in this case, we have some lessons to learn from the common law world. For example, they apply the 3 or 4-step rule, and this rule is substituting an old doctrine which was dominant in the United States legal system, which was called the hot news misappropriation. In a world in which news is a commodity and is into commerce and has economical value, but with a very short life in principle alone, that doctrine doesn't work very well. Instead, they prefer this other one, that is being applied by our courts as well, in civil law systems as well. It is possible to reform the law, I mean, not the code or the act, the law, the conception of law, of applicable rules, through jurisprudence as well in civil law countries, and that's a clear influence from the common law countries as well. Please remember, for those who are Spanish or Basque or Catalan or whatever, when we see a film, an American film about lawyers, we don't see them mentioning to the court the real applicable Article 31 of the criminal code, because they haven't. Instead, we see Tom Cruise searching for decisions that are precedents that condition the final decision of that court in that concrete case, because this is similar to that one, Virginia versus Mackenzie, 1884. That's the way they work, and that's increasingly the work that our courts are working as well, at least in this concrete case. And they apply this rule. The purpose of the transformative rule, I mean, is it for free? It's okay. Is it for profit? Let's negotiate again. The nature of the original work, is it a copyrightable work intended for profit? Let's talk about that. For example, Anne Rice forbids any kind of transformative work. She has a legion of lawyers behind that, and forbids and closes any web page trying to continue the saga of the vampires. Instead, George Lucas accepted after considering it, and J.K. Rowling was very happy to accept continuations of her works whenever they were not for profit. When they're for profit, let's negotiate again. If the transformative work, the derivative work, is about substantial parts or not of the original work, and finally, and more important, is if it's for economical benefit or not. Well, all those rules, the rules that the user accepts when he enters a website, a medium, are placed in this kind of document, the terms of service, terms of use, copyright notice, all of denominations. And look, this seems to be contracts, adhesion contracts. You adhere to that contract, you accept the terms of use or not. And if you accept that, you are binded by that. So it's a binding document, probably a binding contract, in which the user does not negotiate anything. He or she just accepts or not the conditions of the company, which seems not to be very democratic at the end. And it refers again to that famous thing. It's possible for the common people to understand this kind of legal slang. Well, do you understand me? And I used to say, when you deal about law, you need a lawyer. And once again, bad news, instead of bringing my guitar, because I haven't noticed that, and that's his guilty, next time I'll do, I've come dressed with my lawyer suit and not with my wig. But anyway, but the good news is I'm not a real lawyer. Well, I am, but I teach journalism, so I try to be comprehensible. But if you face a real lawyer, especially if you face a real civil lawyer, you have a problem about words and about terms and about concepts, because they are really dense and deliberately complex. So probably we need the help of Groucho and Chico. Well, those rules applicable to the user-generated contents are in that copyright notice or terms of use or terms. And usually they specifically forbid the derivative work. The development of the digital narratives in legal terms comes from this way, and they are strictly forbidden just this thing. Then the question is, why? If these rules are to be applied, even though if they never appear in the contract, of course. If there is no, and I'm referring to civil law concept, which is lucrum animus, animo de lucro, if there is not, because when a media company receives the user-generated content, let's think about the comment, well, that's for free, and the user doesn't want any economical profit. He wants just to see publish his or her opinions and so on and so on. But okay, sometimes they send a video, an exclusive, and scoop. And of course, the media is extremely interested in reselling it to the New York Times, the Guardian, the BBC, and so on. What happens with the violence, for example, of the Catalan police that presumably killed a person in Barcelona? If not were for the citizen participation that recorded that in video, well, the media companies are exploiting economically those contents. So they are not intended for free, and there is lucrum animus. So we are in front on another kind of problems. And they are doing derivative works, which they forbid explicitly. And that's another problem. So what do they do in legal terms? They retain for themselves, and that appear specifically in the contract, the exclusive rights. I mean, if you send something, if you work for hire for me, I understand automatically that the exclusive rights of publication, dissemination, removal, and so on, belong to the company. And there are some exceptions with the user-generated contents. They allow them, in some occasions, to be non-exclusive rights if, and only if, they don't negotiate with third parties. I mean, if they don't produce economical profit. When they do, they consider that they are seated in exclusively. So the user just retains the right to publish the photo, the comment, or whatever, in some other places as well, unless it produces economical profit. Then, let's again negotiate. And especially in the common law tradition countries, they consider that the cession is, perpetual and universal, even though if the acts are national, not universal, harmonized but not universal, and in the civil law countries, the perpetual cession of the work is strictly forbidden by the act. There are some exceptions as well. Well, more than that, they try, and a good example is Grupo Vocento, they try to control the linking strategies, not to which website our links are addressed, but what kind of links do I receive as a media company. And they forbid strictly framing and inline linking, which is nonsense technically in this world, but they try. And it's a usual clause appearing in several or a lot of legal contracts or terms of use. So this is the world we are living in. Some preliminary conclusions of my ongoing research. An increasing trend to control all the contents of the websites produced by the company and its employees or coming from the users. The origin is indifferent. Even though, which is called in the civil law countries industrial property rights and considered in the other tradition intellectual property rights. In Spain or France or Italy, intellectual property is copyright. In England or New Zealand or United States, intellectual property is also trademarks and designs. Okay? In our countries, those kind of things received different legal protection, usually weaker than authors' rights. And, which is more important, control upon third parties' material to negotiate with third parties. Then the company situates itself in the middle, in the center of the economical business of dissemination of news items and contents. And we are leaving them to do that. And of course, and those will refer more properly to ethical rules than to legal rules, the right to limit access to content, for example, the BBC, which is a public broadcasting company. Even more, the general prohibition or interdiction of use of intellectual property rights. So if you send something to a media company, let's see if someone else can use that. Probably not, except of you. A license system also upon third parties' material. Okay, please remember that intellectual property is not real property. It's not like buying a house, at least in Spain, or buying a computer, which is yours forever, and you can give it to someone, or destroy that, or don't know, or give it to your sons, or your sons give it to their sons, and so on and so on. Intellectual property is limited in time. So, in fact, we talk about property, but we can properly speak about ownership. But about a license system, which companies do is to treat that consciously like real property, as if they were the owners, which they are not, of the contents and of the rights on intellectual property. Non-commercial use, in the case of user-generated contents, when there is commercial use, we are in front of different problems. Terms of service as a contract, and that's interesting, I will refer very shortly, because in the common law tradition, if it's a contract, it falls under the so-called doctrine of consideration, which means something for something. Okay, when you, as a user, send something to a media company, they are receiving something. What are you receiving as a payment of that? Do you have any compensation? So can we treat those terms of use as real contracts if there is not counterpart for the user? And even in the civil law countries, it falls under the doctrine of the quid pro quo. And it's doubtful if there is quid pro quo or consideration in those kind of binding documents. I'm not really sure. Probably there is potential. I mean, if the user-generated content produces benefits, then the user must receive some compensation. But if not, the only possible compensation not referred in the contract is of symbolic value. You publish, you become famous for a day, which is quite doubtful. And it's better regulated, of course, in the civil law tradition, for example, in the globo, when it's produced benefits. Let's share that. Okay, we are coming to an end. We have copyright rules and legal rules, ethical rules. We are not referring to that right now, but legal rights and legal rules have some influence on moral rights. For example, the companies logically say that they reserve for themselves the use to publish or remove or modify the contents sent by the user because of the possibility of being libellous. But that goes against the moral rights, the paternity and publication, first publication, and integrity rights. So they have a legal conflict. And some media companies are trying to find a solution about those apparent conflict. For example, Público in Portugal. Okay. Or even though in the common law countries, the BBC. We normally you always have the obligation to in civil law countries, but in common law countries, we usually show your name or not. It depends on the circumstance. And more problems that arouse, and I want to refer to that, citation rights, to which extent are considered, because news items are an exception, a legal exception, all over the world, creating a lot of problems with the scoops in the digital world, because the scoops last very few minutes or seconds on the internet. So you are obliged to mention the source and the author of the original information, and because it falls under the citation exception, but usually they don't do that. But that's another problem. And, which is important, and I've referred to that, removal and revocation rights, which fall under the consideration of the ethical rules, logically, but enter in conflict with the rules of copyright. For example, this clause by The Guardian. Disclaimers of liability, of course, they reserve for themselves all the rights, but they disclaim and liability on possible legal problems. That's the problem of the author as an individual person, which is called in Spanish quite leonino or draconiano. Okay, irrevocability of the cessation of submitting content. Once you submit the content, you can retire it. The only one authorized to do that is the company, not the author himself or herself, which is quite unthinkable. And the only hope is the application of fair use doctrine, even in civil law countries. Well, attractive clauses in a globalized world, especially in the common law countries, in every term of use or copyright notice, it appears an attractive clause. I mean, not an appealing one, which is different. Attractive one, I mean, the courts which decide on possible problems will be those of our country under our laws. Okay, which the exception of the US federal and state laws, which is an interesting case, but it's quite far from our knowledge. Okay, two key concepts, and I'm coming to an end. The nature of the work is important. Multimedia, interactive, collaborative, derivative, transformative work is very important to this respect, and it's a concept that even non-lawyers can easily understand and be careful of. And the question of compensation. As when starting her research on convergence, Laws and Borders explicitly referred in her book on that. Compensation is usually a question that we don't investigate, and that, in my humble opinion, is extremely important. Okay, we have enacted rights written down on a written text in our conception. For example, the tendency to regulate it all in Germany. In fact, they have regulated just what happens with Google News. They haven't regulated, that's from 2009, but after that, Frau Merkel came, so it became nothing at all. And if one should ask about which is my preference, because when I refer to those aspects, usually the audience said, well, do you really prefer the common law system? No, I don't. I prefer that if I live in a common law country. But if I live in a civil law country, I can't prefer that because I can't think like that. Which I prefer, in fact, but it's an ideal wishful thinking, is a legal system, which is a civil law system, like that one, for this concrete aspect, that rules copyright of journalists in the Scandinavian countries, because they are a very good and equalitarian society so far, at least. So far, at least. But which is important, besides the enacting of rights, the reform, the legal reform through the parliament and so on, that's a very civil lawyer conception, nothing to do with common lawyers, is the interpretation of rights. I mean, the law done by the judges. The judge made the law. And that's extremely important. And for example, I'll just mention some cases. The Volkskrant case, which gave the reason to the journalists, or Dernier Nouvelle d'Alsace in France, different legal system and traditions, or Tassini versus the New York Times. Do you remember the case? Tassini was a journalist contracted by the New York Times, the paper edition, and the New York Times wanted to publish his and all the journalist contents also on a CD. They sued the company and they won. But the last year, Tassini sued again because he has a blog in the Huffington Post. The Huffington Post was sold to American Online or to a company, to a great company. So he sued Huffington Post saying, if you are selling that, it's because of me and because all the bloggers that give added value to your contents. So negotiate with me, which is the price or the compensation we are willing to give, to be given. But in this case, the same Court of Appeal of the United States said that Jonathan Tassini was not right, and that he, as an user and not as a journalist, because for the Huffington Post, he's not contracted, he's not working for hire. For the New York Times, say, well, if you accept to give your contents for free to the Huffington Post, don't claim for any compensation if then the website, I mean the collective work, is sold to someone, because you have given your rights, the rights to negotiate upon your own work, to that company with third parties. And that's precisely the thing that they have done. So in this case, Arianna Huffington was the winner. And please look how things have so dramatically changed in very few years, in less than a decade. And that's a way to think. Fortunately, there are some other suitable methods. There's a challenge for my chief in the research project, which is Koldo and Pera and so on. For example, we know very few about the opinion that journalists and users, even high-qualified users, have about their author rights, or even though if they do know what they are. And interviews and surveys, they're going to conduct, so I'm asking, I'm begging, in fact, to include a set of questions about that, so I can gain some more knowledge on the perception of author rights in the part of producers and not of the part of the disseminators, the companies, which I know. And once again, let's try to find out some very high qualified users and journalists, because otherwise we can find ourselves in front of such an interview. This is the other masked brother, Harpo. Okay? But fortunately, we have very good bibliography on the subject. That's an incredibly good introduction to law. If you are searching for something, this is published as well in Spain, and that's just an introduction on how law and lawyers work. So that was a joke, but this is not, because, and I'm finishing. This is a world ruled by Mickey Mouse, and this is not me who's saying that. That's Robert Darnton, the director of the library of Harvard University, saying, we live in a world designed, he's referring to copyright, designed by Mickey Mouse, read in tooth and claw, which means in Spanish, a vida o muerte o a saco. This innocent mouse is governing our laws all over the world. So be careful, because you can have problems with that. And don't laugh at that, because Mickey Mouse has entered the public domain if it wasn't because of the pressure of Disney. They have enacted to lengthen the terms of protection on several creations because of their economical value. And the one that is winning a lot of money with that, it's not the creator, I mean, the painter of Mickey Mouse, but Disney Entertainment's company. So be careful when you send something to somewhere, because I know that there is much more hard work to be done, and any help is most welcome. I beg your pardon for my poor English. My Taylor is rich, my English is extremely poor, but I was asked to do that because of the international audience we are facing here. But estaría encantado si me hiciesen cualquier pregunta en castellano, euskera, portugués, catalán o italiano, que son idiomas que razonablemente conozco. Thank you very much. Eskerrik asko.
Bien, como ha dicho Javier, si hay alguna pregunta, si le queréis interpelar algo. ¿Cuántos de los aquí presentes suelen leer el aviso legal cuando participa en alguna, no sé, haciendo algún comentario o cuando manda alguna foto a algún medio? ¿Alguien se ha detenido en alguna ocasión a leer los avisos legales? ¿Alguien ha tenido esa curiosidad?
Yo.
Bueno, por complementar un poquito lo que está comentando Javier sobre los términos y condiciones de privacidad, más en el ámbito de nuestro proyecto, pues uno de los principales resultados ha sido que, bueno, que en general los jóvenes sí que se preocupan porque haya términos, pero no los leen. Con lo cual, bueno, pues estaría bien que no solo nos preocupáramos por saber que existen, sino por leerlos y saber a qué nos atenemos con los datos personales y con el contenido. Bueno, gracias.
Probablemente de mi intervención se desprenda que esto es un mundo horrible donde las compañías, todas del tipo de Disney, van tras nuestros derechos para forrarse, dejándonos tirados en la estacada. Cuando no es así. Esto es una gran oportunidad para los periodistas y para los usuarios de negociar cosas. Todos estaríamos encantados. YouTube lo hace. YouTube es un repositorio donde tú pones cosas sujeto a determinadas condiciones legales que tampoco leemos, pero que son muy estrictas. Por ejemplo, cuando aparecen menores o cuando aparecen música de fondo que es de Eric Clapton y viene Universal y te dice que de eso nada y te lo retira rápidamente o lo que sea. Pero cuando empieza a haber dinero, YouTube te dice let's share the benefits, repartamos los beneficios. Otra cosa es la proporción de reparto. Claro, si YouTube es de Google, se queda al 99% y tú te quedas el 1%, el reparto no parece muy justo. Y aquí entramos de nuevo en la capacidad de negociación más bien escasa y desde luego no en condiciones de igualdad de nadie. Pero esto es parte del sistema liberal, es decir, lo que subyace bajo la Common Law of Contract y bajo la ley de los contratos en el civil world, es que las partes son libres de negociar, se sientan y llegan a un acuerdo satisfactorio para todo el mundo. Esto no es así. Cuando tú trabajas para una empresa, tú aceptas o no, y te quedas en la calle las condiciones de uso. Y este es el modelo que en todo el mundo han impuesto para los contenidos para los usuarios. Necesariamente porque necesitan controlar la legalidad en términos éticos de esos contenidos, de que nadie introduzca pornografía, incite a la violencia, haga llamamientos xenófobos o lo que sea, ¿de acuerdo? Pero lo extienden obviamente al copyright, con lo cual, si se acepta que esos son contratos, la compañía está ganando de alguna manera, aunque no obtenga beneficios monetarios directos por ello. Por ejemplo, y Pera lo recordará, cuando un medio, lo voy a citar explícitamente, La Vanguardia, acepta miles de comentarios, todos de una calidad, en muchos casos menos que discutible, ¿de acuerdo? No está fallando en la calidad democrática porque no la persigue, persigue el beneficio económico. Y uno dirá, pero bueno, no los vende. No, pero sí que vende a los anunciantes que esta noticia tiene 70.000 comentarios porque la lee mucha gente, ponme el anuncio aquí. No, esto lo están haciendo con la calidad de la noticia, con su propio vehículo y con el número, en este caso no tanto con la calidad de los comentarios, pero cuando New York Times o Le Monde o ahora El País introducen sitios cerrados donde la gente comenta y crea comentarios de calidad o discusiones de calidad, en el fondo está vendiendo su producto y yo creo que el usuario activo que produce comentarios de calidad debería tener algún tipo de beneficio, si no monetario, ya digo, de algún otro tipo. Y en todo caso, si se produce el beneficio monetario, que a veces se produce, por ejemplo, con venta a terceras personas, debería estar previsto por los contratos. Y hay muy pocos medios que lo hacen, solamente, por ejemplo, o Globo lo contempla. Cuando eso se vende y da beneficios, pues veamos cómo lo repartimos. Con otro contrato de adhesión, o sea, no se va a negociar si el 50%, es decir, el 1% lo tomas o lo dejas. Y lo tienes muy difícil para dejarlo porque lo has cedido a perpetuidad con carácter exclusivo y universal. Quiero decir, los abogados, no sé los periodistas y los usuarios si saben lo que hacen o lo que hacemos, pero desde luego que los servicios jurídicos de las empresas saben muy bien lo que hacen. Può parlare italiano, Sivo?
Grazie. Intanto grazie tantissimo per questa presentazione perché penso che l'aspetto legale sia sempre molto importante in qualsiasi discussione, anche perché tira fuori dei problemi grossi. Per esempio, stavo pensando al citizen journalism, tutto il prodotto informativo che viene messo online dai cittadini, dalle persone. Poi arriva il giornalista in redazione alla mattina, la prima cosa che fa, apre il computer e va a vedere in giro per prendere le notizie qua e là. Quindi c'è una sorta di espropriazione continua, no? E se non si riesce a regolare in qualche modo tutto questo, diventa molto difficile lavorare, fare un qualsiasi tipo anche di previsione per il futuro. Poi sono molto d'accordo sul fatto che noi dobbiamo avere molta più capacità di contrattazione rispetto alla common law, perché altrimenti facciamo veramente la fine del topo. In italiano c'è questa immagine, la fine del topo. Grazie.
This one?
Yes.
Posso parlare un po' di italiano, ma posso capire meglio di quello che io parlo. So, can I speak in English or in Spanish? Hablaré en castellano y trataré de hablar despacio y claro. Sí, el término expropiación es un término legal y de uso común que aparece frecuentemente en todas esas cuestiones, como las compañías, los medios se apropian de contenidos. En realidad no lo hacen, no cogen contenidos de nadie, tú se los mandas voluntariamente, mediante un contrato de trabajo, si eres periodista o si eres un usuario, voluntariamente porque quieres ver tu foto colgada ahí. El problema está cuando todo esto se monetariza. Es obvio, y no hemos hablado de esto, que el modelo de negocio actual en el periodismo online es que monetariza poco. It doesn't become money at the end. They sell more prestige than money at the end. Pero de alguna manera y de forma indirecta hay un beneficio económico. y si no lo hay un lucro cesante. Es decir, yo dejo de ganar lo que usted está regalando por ahí. Con lo cual nos enfrentamos, por una parte, a criterios éticos, es decir, sea usted cuidadoso con los contenidos ajenos y mencione el nombre de su autor, a lo que está obligado legalmente y en todas las legislaciones del mundo, y nada la exime de esto. Pero por otra parte, en fin, la tecnología va muy, muy deprisa y las obras derivadas o transformadas son muy habituales y son beneficiosas en muchos casos para George Lucas. George Lucas ha aceptado que haya secuelas, precuelas, novelas, cómics, siempre por la red, siempre que no le perjudiquen económicamente, porque son su creación. La cual cosa es a veces muy difícil, porque en cuanto entra un anuncio de YouTube... Pero en el caso de George Lucas, los abogados del Lucasfilm Company entran rápidamente y te dicen de manera poco amistosa que retires eso rápidamente. Es decir, que hay motivos. En el fondo, lo que ocurre con la legislación de derechos de autor o de propiedad intelectual es que los problemas parecen nuevos, pero no lo son. Son los mismos problemas de siempre. Un señor escribió la segunda parte del Quijote sin permiso de Cervantes. Es decir, hizo transmedia en el siglo XVI. Y Cervantes reaccionó publicando rápidamente su segunda parte porque eso le restaba beneficios a él y a su impresor y a su editor y a la gente que ponía el dinero, al noble que le pagaba. Es decir, Internet lo que ha hecho es multiplicar y globalizar problemas que ya existían, sin que de forma paralela por parte del usuario final haya, y sobre eso falta investigación, una verdadera percepción de que eso es importante y de que como parte del proceso de producción debería tener en cuenta esos derechos porque son suyos originariamente. Y solo cuando los cede pasan a una esfera que no controla bien o no controla para su propio interés. I've managed to answer you. Thank you.
Bien, ¿alguna otra cuestión? ¿Pregunta? Pues...
Profesor, mira, soy brasileño, pero voy a intentar hablar en español.
Posso falar português? Como você está aqui da Bahia.
Aliás, a sua contribuição no Brasil é muito conhecida e muito admirada,
obrigado.
Professor. Muito obrigado pela contribuição que o senhor vem dando aos estudos de comunicação no Brasil.
Muito obrigado. Adoro o Brasil.
Bueno... Pero en respecto a tu idioma, voy a intentar hablar en castellano.
Gracias.
Profesor, mira, en los últimos años yo estoy pensando que nos quedamos algo deslumbrados, encantados con las lenguajes multimediáticas y transmediáticas y nos olvidamos de investigar y de estudiar las implicaciones económicas y legales de estos cambios que están sucediendo, que están ocurriendo en la comunicación. Entonces me gustaría parabenizar, congratular tu iniciativa de estudiar estos asuntos. Y yo también intento hacer algo así, estudiando nuevos modelos de negocio para el periodismo. No que esto me encante, en realidad me encanta muy poco. Me gustaría estar estudiando filosofía y lenguaje y comunicación, pero estoy convencido que el problema central hoy día es un problema económico y legal, porque en las nuevas estrategias de financiación de los medios están envasadas en problemas legales como la expropiación y la explotación no solo de los contenidos generados por los usuarios, pero los datos que ellos dejan cuando trafegan por estos sitios, ¿no? Pero todavía no estoy percibiendo una atención debida de las facultades de periodismo y de comunicación a estos asuntos. Sin embargo, hay muchos ejemplos de problemas prácticos de las empresas de comunicación en esto. Podría dar ejemplos y podría hablar sobre iniciativas que yo veo como cruciales, pero no hay tiempo. Entonces me quedo a preguntarte, ¿Cómo se puede incentivar las facultades de periodismo a tratar de estos problemas en nivel de grado y posgrado? Porque los estudiantes están siendo formados para un mundo y ellos no dominan algunos conocimientos que se van a ser necesarios en 1 o 2 años cuando estén trabajando en el mercado de trabajo para problemas económicos y para problemas jurídicos legales. Muchas gracias.
Obrigado pela pergunta. Eu vou tentar eu gostaria de falar portugués, mas o público, ni todo el mundo sabe. Hablo entonces en castellano. Es una pregunta, yo creo que pertinente, pero diría que no soy la persona apropiada para responderlo, porque no tengo cargos académicos. Dirijo un máster de investigación que tiene poco que ver con esto. Pero aquí, Koldo se ha ido, hay personas que sí tienen cargos académicos y que serían más apropiadas para responder a esto. De hecho, veo algunas caras. Me vais a permitir que os saque del anonimato del público, de convertiros en people formerly known as the audience. Bella Palomo se ha referido a esto y es secretaria de departamento. Pera Masip tiene cargo académico y tiene algo que decir. Delante tienes a Irene da Rocha, que también está haciendo una investigación sobre la enseñanza de los procesos de convergencia en los medios en la universidad. Y mi conocimiento de la ley es poco y limitado al copyright y a los author's rights, a los derechos de autor, pero no me atrevería a ir mucho más allá cuando, ya digo, entre el público hay personas a las que cedo mi asiento y mi micrófono y te lo van a responder mucho mejor que yo. Gracias. Luis.
Bueno, como somos pocos, hay confianza. No solo soy secretaria del departamento, sino que soy coordinadora de los estudios de periodismo en la Universidad de Málaga, lo que me ha permitido hacer un análisis crítico de la situación no ya en mi universidad, sino en el resto de grados de este país. Y me temo que el problema es en el formato escogido a la hora de diseñar un plan de estudios, ¿no? Donde normalmente no es un formato participativo, abierto a que todos los integrantes de un departamento puedan realizar sugerencias, mejoras a implementar en ese plan de estudios. Y desgraciadamente, y lo diré como esto no va a ser emitido en plan off the record, normalmente son los grandes dinosaurios académicos los que desarrollan los planes de estudios. Entonces, no, yo no he puesto categorías, más que he puesto algo más genérico. Ya no digo que tengan que ser ni catedráticos ni titulares, no voy a entrar en esa polémica, pero sí que es cierto que la gran pregunta que se están haciendo todos los periodistas hoy es ¿hasta cuándo tengo que seguir reciclándome, adaptándome a nuevos escenarios de comunicación? Es probablemente la que tengamos que trasladar también a la universidad, a los profesores. ¿Hasta cuándo tienes que seguir formándote, actualizando tus programas, adaptándote a nuevos escenarios y a nuevas asignaturas? Pues durante el resto de toda nuestra vida. Es decir, esa etapa formativa, universitaria, transitoria de 4 años y el resto de tu vida simplemente a practicar lo que has aprendido en esos 4 años, eso ya no existe y no vamos a volver a ello. Entonces es un cambio de mentalidad que lo mismo que se tiene que instalar en la mente de los profesionales, de los periodistas, también se tiene que instalar en la mente de los docentes. Cedo mi puesto al siguiente.
Bueno, pues ahora ya sí, ya desesperado, ya con todo políglotas que somos, italiano. Ez bakarrik esatea hori, eskerrak emotea, hori Javierrek badaki be bai, euskaraz hitz egiten, osea, eta hori bakarrik falta jakoia gaur goizean. Hasierako moduan esan genuenez, eskerrik asko ziberkazetzaritza eta web 2.0 kongreso honetara etortzagatik, egia esan badakit esfortzu handia egin duzuela hemen egotegatik. Eta, bueno, bakarrik hori, eskerrak emon, datorren urtean berriro be, uste dut hemen egongo garela naiz eta betiko moduan, beti esan gauza bera, hau, ja, azkena dala eta ez dakizen, baina, bueno, seguramente datorren urtean 6. edizioa antolatuko dugu. Eskerrak eman nahi dizkizuet bebai, nire alboan egon diren guztiei, Ainara, Irati, Txus, tabarat, etorri diren ponente guztiei, badakit batzuk esfortzu handia egin dutela hemen egotearren, eta esandakoa. Gracias a todos y a todas por haber aguantado estoicamente hasta las 2 del mediodía, por haber venido al Congreso, por haber estado presentes durante estos 2 días intensos y de aquella manera. Y simplemente, pues eso, lo dicho, los certificados ya os lo enviaré y simplemente volver a veros en la 6ª edición, que a buen seguro, aunque siempre lo digo en letra pequeña, no habrá, pero que sí nos estaremos aquí en el 2014. Eskerrik asko, thank you, obrigado.